Article 4, Section 2. Common interpretation by Ariella Gross and David R. Upham. Introduction. Our Constitution's fourth article is devoted to the relations between the states and the Union. Section 2 of that article sets forth 3 clauses, each of which concerns the movement of persons throughout the Union. The first of these, the Privileges and Immunity Clause, stipulates that the citizens of each state shall enjoy the privileges and immunities of citizens in the other state. Conversely, where the interstate traveler is a fugitive from criminal justice, the second provision, extradition clause, requires the person's forcible rendition to the state where the alleged crime occurred. Finally, the fugitive slave clause, now obsolete, extended this rule of coercive rendition to interstate fugitives from slavery, that is, fugitives from injustice. Unlike the other clauses, Article 4, the provisions in Section 2 vest in Congress no express enforcement power or duty. Instead, each uses a passive voice verb, shall be entitled in the first clause and shall be delivered up in the second or third clauses without any clear identification of the authority or authorities who are to ensure this entitlement or this rendition. The provisions mention only the persons entitled to the benefit, the citizen under the Privileges and Immunities Clause, the executive of the state's alleged crime under the Extradition Clause, and although not named as such, the slaveholder under the Fugitive Slave Clause. Before the Civil War, the Fugitive Slave Clause and the Privileges and Immunity Clause occasioned intense national controversy. Americans disagreed about both the scope of these provisions and the degree to which the federal government and some implied power or duty to enforce them. These legal disputes in turn reflect deep political divisions on questions related to slavery, race, and citizenship. Since the Civil War, Article 4, Section 2 has been largely uncontroversial. By abolishing slavery and securing blank citizenship, the Reconstruction Amendments largely resolved the antebellum disputes arising under Article 4. Today, jurists largely agree as to the essential meaning of the 3 clauses. The Privileges and Immunities Clause. According to the currently prevailing interpretation, the Privileges and Immunity Clause entitles citizens of one state while sojourning in other states to equal treatment with the local citizens. That is to say, the clause prohibits discrimination on the basis of a citizen's state of residence. The anti-discrimination rule extends to certain fundamental rights that a state may afford its own citizens, including rights of travel, residence, trade, employment, property, and others. Still, despite the mention of all privileges and immunities, some rights fall outside the anti-discrimination rule. The states remain free to discriminate in favor of their own citizens and to the political rights of voting and office holding, and non-fundamental activities like recreational hunting and fishing. The adoption of the Privileges and Immunity Clause addresses a key problem inherent in the new federal system. On July the 4th, 1776, the representatives of one people and declared that the 13 united colonies were free and independent states. From the beginning, the United States was marked by a tension between unity and multiplicity, one united people but 13 independent states. And from the beginning, this tension posed many challenges, including the threat that the several states' independence would turn former fellow British subjects into citizens of 13 separate republics, mutual aliens rather than one people. To meet this danger, the Articles of Confederation included a provision expressly designed to secure and perpetuate mutual friendship and intercourse among the people of the different states in this union. By this rule, the free inhabitants of each state would not be foreigners, vice versa, the others, but instead entitled to all privileges and immunities of free citizens in the several states. These privileges included the freedom of ingress and regress, and all the privileges of trade and commerce, subject to the same duties, impositions, and restrictions, and the inhabitants thereof respectively. This promise was, as Alexander Hamilton would note, the very basis of the Union. With a few modifications, the fourth article of the Constitution retained this provision from the Articles of Confederation. For the most part, it generated little discussion and debate during the founding era, probably because it was inherently conservative, preserving an existing understanding of interstate norms, and because there were few substantive disputes among states, with the notable exception of those regarding slavery. One omission, however, did prompt some modest dissent. Under the Articles, the citizen had enjoyed express exemption from any local legislation that would prevent the removal of property imported into any state, back to the citizen's home state. The probable purpose of this provision was to protect non-resident slaveholders against local anti-slavery law, or the objection of Southern colonialist Charles Pinckney and some other slaveholding delegates. The convention proved the omission of this guarantee. Decades later, slavery would provoke more intense conflict over the interpretation of the Privileges and Immunity Clause. Two main disputes developed and intensified in the decades before the Civil War. First, as the northern state grew increasingly intolerant of slavery, many slaveholders insisted that the clause secured what its drafters had omitted, a right to travel in the free states, exempt from local anti-slavery law. Some northern courts agreed, but other authorities replied that the traveling slave owners were entitled only to equality with the local citizens and could thus lose any property rights immediately upon the slave's entry into the state. Second, as southern and western states became increasingly intolerant of free black residents, many objected that the new laws restricting the rights of free people of color violated their citizenship rights. But the authority in the Southwest generally upheld these racist policies primarily on the claim that the free blacks were non-Americans and did not qualify as citizens under Article 4, but also on the interpretation that even if citizens, free people of color, were entitled to no more than the major rights, if any, the local laws afforded to native Negro populations. On the eve of the Civil War, a third related dispute arose. Increasing Southern intolerance of anti-slavery opinion effectively prevented anti-slavery Americans from traveling in the South. Southerners defended this policy's consistency with Article 4 on interstate equality grounds. But some anti-slavery Northerners argued that the Constitution entitled citizens to the right to travel, and even to express their opinions in every state of the Union, local anti-slavery policies to the country notwithstanding. According to Abraham Lincoln and many other Republicans, Congress had as much power to secure these entitlements and to enforce the Fugitive Slave Clause. The Extradition Clause. The Extradition Clause provides for the return of persons charged with a crime in one state who fled to another state. In some ways, the Extradition Clause was the mirror image of the Privileges and Immunities Clause. The flip side of the interstate citizenship was interstate cooperation, whereby each state would help to enforce the criminal jurisdiction of the other states. Accordingly, the Articles of Confederation mandated the interstate rendition of fugitives from justice, that is, from criminal accusation, process, and punishment. Article 4, Section 2, likewise, provided for the return of persons charged with a crime on one state who fled to another state, with only minor changes from the wording in the Articles. The Extradition Clause provided that the executive authority of the state from which he fled should demand the rendition of the fugitive, soon a copy of the indictment or sworn affidavit certified by the governor was required for extradition. However, because the provision was not self-executing, it required legislation to put it in effect. This became evident when Virginia refused to deal up to Pennsylvania 3 fugitives from justice who had been accused of kidnapping a free black man, John Davis, just 1 year after the adoption of the Constitution. This controversy led Congress to include a extradition clause in what became known as the Fugitive Slave Clause of 1793. The language of this legislation mirrors that of Article 4, Section 2, but declared it the duty of the executive authority to act on an extradition request. Although many fewer conflicts arose regarding the extradition clause than the Fugitive Slave Clause, those indeed all had to do with slavery. One such a case set a precedent that was not overturned for over a century, Kentucky versus Dennison, 1860. In that case, Ohio Governor William Dennison Jr. refused to extradite a fugitive from Kentucky who had been charged with helping a girl escaping from slavery. The court ruled that although the governor had the duty to return the fugitive from justice, he could not be compelled to do so by a writ for mandamus. This precedent was not overturned until the 1987 case of Puerto Rico versus Branstad. Today, the Uniform Extradition Act had been adopted in 48 states, Puerto Rico, the Virginia Islands, but not Mississippi and South Carolina. The extradition clause covers treason, felony, or other crime. The Supreme Court has interpreted the crimes for which a person is subject to extradition more broadly to include every offense punishable by law of the state in which the offense was committed. It is not a requirement that the accused consciously fled to avoid persecution, only then the person did in fact flee from justice. The Fugitive Slave Clause. The third clause, Article 4, Section 2, is known as the Fugitive Slave Clause. It is one of the 5 clauses in the Constitution that dealt directly with slavery. Although it does not use the word slave, it instead refers to persons held to service or labor, compared to the Slave Trade Clause and the 3/5 Clause. The Fugitive Slave Clause occasioned very little debate at the time it was adopted, but fierce conflicts arose about its scope and enforcement in the decades that followed. The clause was adopted under the Constitutional Convention of 1787 on the motion of Pierce Butler and Charles Pinckney of South Carolina. In opposition, James Wilson of Pennsylvania disagreed because this would oblige the executive of the state to return fugitive slaves and the public expense. The proposal was withdrawn but then adopted a day later with no dispute. The only response recorded was Connecticut Delegate Roger Sherman's sarcastic comment that he saw no more propriety in the public seizing and the surrendering a slave or servant than a horse. Over the course of the Constitutional Convention ensues relating to slavery complicated nearly every debate, and the importance of slavery became increasingly evident. In the Convention's final actions on slavery-related matters, the language of the Fugitive Slave Clause were discussed and amended. The Committee of Detail reported the language, "No person legally held to service or labor in one state escaping to another shall be discharged for such a service or labor." The Convention substituted the term "under the law thereof" after the word state for the term legally. The delegates made this change to satisfy those who sought to distance themselves from the institution of slavery and make clear it was a local institution only in certain states. This was a small triumph for those who were uneasy about slavery, but it had no practical effect. At the end of the day, since the word slavery was never mentioned in the document, Northerners could argue that the Constitution did not recognize the legality of slavery. However, Southerners such as General Cosworth Pinckney argued that we have obtained the right to recover our slaves in whatever parts of America. They may take refuge, which is a right we had not before. Ultimately, the insular slavery's constitutional standards was far from settled. Like the other two clauses, the Fugitive Slave Clause did not provide for any particular enforcement powers. Congress passed the Fugitive Slave Act of 1793 with almost no opposition or debate to provide for enforcement. The act authorized a slave owner or his agents to cross state lines, seize an alleged fugitive slave, take the slave before any judge or local magistrates, and thereupon prove ownership, receive a certificate entitling him to return home with his captive. Financial penalties could result for interfering with the recovery of a fugitive. Law's evidentiary requirements were loose, and oral testimony was sufficient. It did not provide for normal legal processes like trial by jury. It gave the alleged fugitive no protection against self-incrimination and no assurance that he could testify on his own behalf. It also did not specify a time limitation, so slave could be claimed many years after the alleged escape. From the 1830 until 1850, many northern states attempted to provide some legal protections for escaped slaves who face potential recapture in the North by passing personal liberty laws. This law forbade the participation of state authorities or the use of state property in the capture of a fugitive. Other laws provided runaway slaves with the procedural protections that were not specified in the Act, such as trial by jury and the right to testify. By and large, however, a constitutional settlement prevailed in both northern and southern states. States had the right to determine the legal standards of their own inhabitants, including defining people as slaves and authorizing their re-enslavement if they run away to a free state. But states also had the authority to punish a kidnapper for reducing a free person to slavery and to define procedures to protect free people from a kidnapping. Prague versus Pennsylvania, 1842, tested the constitutionality of the Pennsylvania personal liberty law. Edward Prague had been convicted on kidnapping charges in Pennsylvania for taking a recaptured fugitive slave back to Maryland without obtaining the required certificate. The court found that the Pennsylvania statute on which Prague had been indicted, was in conflict with the federal law of 1793 and with the Constitution. Thus, the historian's decision was based on his belief that the Fusilier Clause constituted a fundamental article, without the adoption of which the Union could not have been formed. Therefore, seizure and the recapture of fugitive slaves was a basic constitutional right, and the states could not pass laws interfering with the right. The opinion held that only Congress had the power to pass legislation implementing the Fusilier Clause. The judicial nationalism threatened to upend the old constitutional settlement. As the sectional conflict increased, the constitutional settlement that had prevailed among the states began to break down, and the majority court opined in Scott versus Emerson times not as they were when the former decisions on this subject were made. Northern and Southern courts stopped extending comity or respect to one another's decisions. The compromise of 1850 included a even more stringent new Fugitive Slave Act, in which the suspected fugitives were denied the right to trial by jury and the right to testify in their own behalf. The act made rendition of fugitive slaves a federal affair, forbidding state officers to interfere with federal marshals and making it a criminal offense for private citizens to do so. Nevertheless, abolitionists in northern states formed vigilance committees to ward off slave catchers and kidnappers and conducted spectacular rescues. Northern juries refused to convict rescuers when the high courts in Wisconsin and Ohio held the 1850 Fugitive Slave Act unconstitutional in 1854. They did so with broad popular support, although the U.S. Supreme Court eventually overturned the decisions in 1859. In Abelman versus Booth, by that time, it was quite clear that North and South were on a collision course. And the heart of this antebellum controversies was a more fundamental disagreement. What is the relationship between slavery and the Constitution? Did the Constitution condone, support, and protect slavery, or was it silent on slavery's legality, allowing it for the institution to wither away in the future? Pro-slavery Southerners were virtually unanimous in asserting the centrality of slavery to the Constitution. Besides celebrating the undeniably pro-slavery provisions, they asserted that one of the fundamental privileges of American citizens was the right to travel and even stay for long periods of time anywhere in the Union with enslaved human property. Even among anti-slavery advocates, there was sharp disagreements about how to interpret the Fugitive Slave Clause and the slave clauses of the Constitution as a general matter. Taking one extreme view, William Leon Garrison describes the Constitution as a pro-slavery, war-sanctioning Constitution of the United States. This view had much in common with the Southern views on the Constitution. Garrison declared the Constitution to be a covenant with death, an agreement with hell, precisely for the reason that it did sanction slavery. By contrast, Frederick Douglass held a minority viewpoint within anti-slavery politics based on the textualist reading of the Constitution. Douglass argued that the Constitution made slavery illegitimate everywhere in the South as well as in the territories. He argued that the Constitution does not explicitly condone slavery, and the written Constitution should not be interpreted in light of secret and unwritten understanding of the framers. Douglass believed that the federal government could abolish slavery because it violated the Fifth Amendment due process guarantee, the Article 4 guarantee for Republican government, and other clauses of the Constitution. He also made originalist arguments about the founders' intentions to have slavery gradually wither away. By this understanding, the The Constitution had become corrupted by acquiescence in pro-slavery custom. But the Constitution's adversary character could be redeemed by federal action. He also relied on a natural law interpretation of the Constitution, arguing that it should be read in conjunction with the Declaration of Independence and given the meaning that best expressed in the ideals of the Declaration. A third understanding was exemplified by Lincoln and other moderately adversary Americans. The Constitution did indeed contain concession to slavery, but these were compromises, not principles. The Constitution's principles were fully compatible with the eventual abolishing slavery, whether by state legislation and federal territorial legislation, and if necessary because of minority intercessions, eventual constitutional amendment. As William Seward argued, slavery was merely temporary, accidental, partial, and incongruous. But freedom was perpetual, organic, universal, in harmony with the Constitution of the United States. For the most part, the Reconstruction Amendments resolved this Article 4 controversies. By abolishing slavery throughout the Union, the 13th Amendment nullified any person's right to enjoy the rendition of fugitive slaves or to travel with slaves, and the 14th Amendment replaced the Privileges and Immunities Clause as the most solid basis for protecting all Americans, regardless of race, state of residency, or otherwise, against state infringement of their fundamental rights as citizens. Nonetheless, the antebellum debate as to slavery's place in the Constitution have to some extent continued to this day. In 1987, Justice Thurgood Marshall gave a speech cautioning against the flag-waving fervor of the bicentennial celebration of the Constitution, explaining that the 1787 Constitution was defective from the start, requiring several amendments, a civil war, and momentous social transformation to attain the system for constitutional government. It is respect for the individual freedoms and the human rights we hold as fundamental today. Then Assistant Attorney General William Bradford Reynolds responded in the speech later that month that it was wrong to think that there was two constitutions, the one of 1787 and the one of today. If the Constitution acknowledged or lent support to slavery, then support was necessary to the political compromise that secured its ratification. The debates about whether the 1787 Constitution did or did not support slavery, based on the wording and the adoption of the slave-related clauses, contributed to one's views of the Constitution as a living, changing document, or one that still means what it did in 1787.